Marriage isn't just rings, promises, and maybe some regret. It also comes with governments acting as the strangest possible third wheel. Across the world, obscure laws turn weddings into something closer to a courtroom sketch than a love story. Some countries ban you from marrying too many times, others tie marriage to military service, and modern digital rules make paperwork stranger than ever. This countdown covers 45 marriage laws that prove bureaucracy and romance rarely mix. And we'll start with a rule that shows even death isn't always the end of the marriage process. Marrying the dead in France. In France, the law allows something both unusual and deeply emotional, marrying someone who has already passed away. This practice, known as posthumous marriage, was originally created to recognize the fiancés of soldiers killed in wartime. Today, it remains available to civilians, but it requires one extraordinary step. You must submit a petition directly to the President of France. The request won't be approved without convincing proof that the marriage was truly intended before death occurred. Letters, legal filings, or documented plans can all serve as evidence. If permission is granted, the wedding is legally recognized and even dated to the day before the partner's death. While it can carry personal meaning, the decision isn't purely symbolic. It affects inheritance rights, survivor benefits, and the legal status of the surviving spouse. This unusual option demonstrates how marriage law sometimes bends to meet grief with bureaucracy instead of compassion. It offers a strange kind of closure, but also raises questions about where the boundaries of marriage truly lie. Yes, under French law you can marry the dead, provided you can persuade the highest office in the country. And if that sounds strange, the next law shows governments also step in when the problem isn't death, but deception. The crime of fake proposals. In South Carolina, a marriage proposal isn't always just a romantic gesture. It can cross into the world of criminal law. Under state statute, making a proposal with no intention of marrying isn't treated like a prank or a harmless joke. It's defined as fraud, and anyone accused could be charged with a misdemeanor. The law was written to target serious emotional deception, like stringing someone along for personal gain, not just casual embarrassment. The odd part is how narrowly it's framed. The rule applies to any man over the age of 16 who proposes to a woman while acting with deceitful intent. If that intent can be shown, the offense falls under a section called Offenses Against Morality and Decency. That alone reveals the lawmaker's stance, that this isn't merely about hurt feelings, but about preserving public ethics. Of course, proving what truly motivated a proposal is nearly impossible. Courts would need to demonstrate intent, which makes prosecutions extremely rare. The statute has less to do with putting people in jail and more to do with signaling how serious the state views fraudulent proposals. Still, the idea stands. In South Carolina, popping the question without meaning it could land you in legal trouble. Ever seen a viral fake proposal video online and wondered if it crossed the line? Drop a comment and let us know. And while South Carolina polices intent, other states write their rules around biology instead. The 65-year-old cousin clause. In Utah, cousin marriage is on the books, but only under very specific conditions. The law blocks first cousins from marrying until both partners reach the age of 65. There's one earlier exception. If both cousins are at least 55 and a court certifies that one or both cannot have children, the marriage is permitted. Outside of those two scenarios, the law remains firm. No license gets issued. The rule isn't built around questions of family tradition or social discomfort. It's explained as a safeguard against genetic risk. Lawmakers designed the age cutoff and infertility exception, so the possibility of children and the concerns tied to that are effectively eliminated. By 65, fertility is statistically negligible. At 55, a court can confirm infertility and close the issue. What makes this clause unusual is how blunt the criteria are. It doesn't rely on complicated genetic testing or case-by-case discretion. It sets two clear thresholds, age or medical certification, and treats them as the end of the discussion. As soon as those boxes are checked, the restriction disappears. This is one of the few marriage laws that hinges almost entirely on biology. But not all states lean on science to set boundaries. Some, instead, draw hard lines based on patterns of behavior. Kentucky's three-strike marriage rule. Kentucky has one of the most unusual limits on marriage in the U.S., a strict three-strike rule. The state allows you to marry, divorce, and remarry the same person up to 3 times, but try for a 4th round and the law shuts the door. At that point, the county clerk is required to deny the license, no matter how heartfelt the reunion may seem. This cutoff doesn't depend on the details of the relationship. It doesn't consider how long you stayed apart, who initiated the divorces, or whether decades have passed since the last attempt. The statute is a hard line. 3 marriages with the same partner are allowed, while a 4th is impossible. It turns a deeply personal decision into a simple tally where the government keeps score and enforces the limit. The state's message is blunt. While reconciliation is tolerated more than once, the law makes it clear that an endless cycle isn't something Kentucky will recognize. Some lawmakers saw fit to frame repeated remarriages not as romantic persistence, but as a harmful pattern. In effect, the state tolerates 2nd and 3rd chances, but declares the 4th one a step too far. How many second chances is too many? That question lingers, especially when, in some places, your biggest obstacle isn't your partner's history, but outside approval that can stop the wedding altogether. Monaco's royal wedding veto. In Monaco, marriage comes with a gatekeeper unlike almost anywhere else, the sovereign prince. For citizens of the tiny principality, no wedding can move forward unless approval is first granted by the royal palace. This requirement isn't symbolic, it functions as real legal authority, and without it, no marriage license is issued. Before approval is given, the law requires your intent to marry to be posted publicly for 10 days. During that short window, objections can be raised, but the ultimate decision rests with the prince himself. If his office files an objection, the process halts immediately, and there's no guaranteed timeline for when, or even if, the block might be lifted. In practice, this system leaves every citizen's personal life subject to direct royal oversight. The origins of the rule date back to an era when subjects, unions were viewed as matters of dynastic security and social control. While most modern states treat marriage as a private choice, Monaco continues to embed it within the framework of sovereign control, preserving a clear reminder of its monarchical tradition. It's hard to ignore the irony. In a world of dating apps and casual breakups, citizens of Monaco still have to clear their relationships with a monarch. And in the next example, other places handle relationship fallout very differently, turning private heartbreak into a courtroom battle. Suing your spouse's lover. In a handful of U.S. states, betrayal doesn't just play out at home, it can head straight into the courthouse. North Carolina is one of the most famous examples where alienation of affection lawsuits are still allowed. These claims let a betrayed spouse sue the person their partner cheated with and demand money for the damage caused. The case doesn't rest entirely on proving an affair happened. Instead, the law asks whether a marriage had genuine affection and whether a third party acted to deliberately interfere with it. That could mean physical infidelity, but it could also cover manipulative actions that undermine the relationship. It shifts the focus from the straying spouse to the outsider accused of causing the breakup. The financial stakes are far from symbolic. Juries have awarded damages that range from 6 figures to millions of dollars, making the price of an affair in North Carolina potentially life-changing. Supporters argue it's a way of holding people accountable for knowingly breaking up marriages, while critics see it as a system that monetizes heartbreak and turns personal pain into a cash award. Either way, it's one of the rare places where love lost in court can come with a dollar amount attached. Would you sue? And while some states attach financial rewards to broken vows, elsewhere, the law interferes in something as simple as choosing a date for the ceremony. Delaware's Sunday wedding ban. In Delaware, weddings can get tripped up not by family drama, but by the calendar itself. A long-standing rule prohibits marriages on Sundays unless couples apply for and receive a waiver. Without that approval, a Sunday ceremony isn't recognized legally. No matter how many guests witness the vows, the marriage remains invalid in the eyes of the state. This restriction comes straight from the remnants of old blue laws, which were built to protect Sunday as a day of rest. Most states scrapped these rules decades ago, but Delaware still enforces this unusual limit. The only way around it is government approval, which means anyone determined to marry on a Sunday has to secure official permission first. For many couples, that extra step is enough to make Saturday the safer choice. The law also provides another odd safeguard tucked into its provisions. If someone says, "I do," as part of a joke or a dare, the state's statutes treat that situation seriously. Delaware lists jest or dare as valid grounds for annulment, offering a legal escape hatch for marriages that were never meant to be taken seriously in the first place. And while Delaware focuses on invalidating unserious unions, another state took aim at a different kind of deception, when false promises themselves are written into law as a crime. The crime of seduction in Michigan. In Michigan, a broken promise of marriage isn't just seen as betrayal, it can be treated as a crime. The law still makes it illegal to seduce and debauch an unmarried woman by pretending a wedding is in her future. At its core, the statute targets someone who falsely promises marriage as a way to obtain intimacy. It elevates what might look like a personal wrong into a legal offense. The phrasing may sound archaic, but the intent is straightforward. Using deception to secure a relationship was framed as criminal exploitation. When the law was written, a woman's reputation and chances at future marriage were considered fragile enough that such lies could cause permanent harm. By criminalizing seduction under false pretenses, Michigan sought to cast emotional manipulation as something deserving of state punishment. Prosecutions under this rule are virtually unheard of today, but the statute hasn't disappeared. On paper, it remains a felony-level offense. What was once viewed as moral protection now lingers as a relic, pointing back to a time when the state saw itself as the defender of personal virtue as much as public order. And as unusual as it is to define intimacy through criminal law, in some places officials went even further, placing medical scrutiny itself at the front door of marriage. Vermont's pre-wedding blood mandate. In Vermont, a marriage license requires more than signatures and witnesses. It begins with blood work. State law still mandates that anyone applying must first take a blood test for syphilis, with results submitted directly to the clerk before the license is issued. Without that signed medical form, the application simply stops, leaving no path forward until the test is complete. What feels like a routine marriage errand turns into a medical appointment that every couple must navigate. This requirement wasn't designed for paperwork's sake. It dates back to the early 20th century, when syphilis was a serious public health threat and legislators saw premarital testing as a way to block transmission and protect future children. Through the mid-century, many states adopted similar rules, but nearly all later discarded them as outdated. Vermont, however, never fully let go of the statute. Today, the rule functions less as a public health safeguard and more as a lingering reminder of how governments once tied personal milestones to medical oversight. Critics argue the mandate adds needless costs and stress for couples, given modern advances in diagnostics and treatment. Yet the law remains in the books, shaping marriage in ways that feel out of step with current healthcare standards. Law and old-time morality do not always update together. And in another corner of America, tradition collides with bureaucracy again, this time where quick weddings are part of the culture, and even spontaneity has to pass through new layers of control. Nevada's digital drive-thru. Nevada has long been the capital of quick weddings, with drive-thru chapels that let couples trade rings in less time than it takes to order lunch. But even those famously fast ceremonies aren't as simple as they once were. In recent years, lawmakers have introduced tighter checks on licenses, ensuring spontaneous nuptials don't slip past basic fraud controls. So while an Elvis impersonator can still officiate from behind a counter, the paperwork now carries more weight than just a hurried signature. Instead of bypassing procedure altogether, couples today face identity confirmations and stricter records before a clerk can issue a license. Some offices use digital systems to reduce fraud, treating marriage documents less like party favors and more like legal contracts tied to databases. The intent is practical, stopping sham marriages, securing records, and making sure split-second decisions meet a paper trail officials trust. Yet the spirit of Nevada's wedding industry hasn't changed. A couple can step off a plane, rent a car, and be newly married the same afternoon, complete with flashing lights and themed chapels. The key difference is that behind the showmanship, every union leaves an official trace that's harder to undo the next morning. That tension between personal impulse and outside oversight sets the stage for other places where marriage isn't just about love at all, but about passing through intricate approval systems before the ceremony even begins. Japan's family gauntlet. Marrying a Japanese national as a foreigner often feels less like planning a wedding and more like navigating a full-scale review. The process isn't confined to two people deciding to build a life together. It overlaps with Japan's household registry system, the Koski asterisk, which anchors family identity to official records. Updating the registry after marriage is straightforward on paper, but in practice, family expectations and cooperation frequently shape how smoothly the process moves forward. Don't be surprised if what you imagined as a quiet ceremony begins to resemble a family board meeting. That influence extends beyond social tension. While Japanese law does not give relatives a formal veto, disapproval can complicate paperwork, delay approvals at local offices, or cast extra scrutiny on the couple. For foreigners, there's also a standard set of additional requirements. Most embassies issue what's known as a certificate of no impediment, confirming that the applicant is legally free to marry. This document, paired with family introductions and background checks, means the process goes well beyond filling out a single form. In many cases, education, employment, and even perceived character come under review. What emerges isn't a simple administrative formality, but an evaluation by both the state and the family structure. The marriage becomes a negotiation of personal choice within collective approval. Some places stop at social and administrative pressure, but elsewhere, the authority to block a marriage is written directly into law. Saudi Arabia's guardian consent. In Saudi Arabia, marriage contracts rest on one signature that carries more weight than any vow, the consent of a male guardian, called a asterisk wali asterisk. Without that approval, the contract is not valid, and the state refuses to recognize the union, no matter the wishes of the couple themselves. A woman cannot finalize her marriage independently. The decision is, by law, incomplete without someone else's authorization. The guardian role usually falls to the father, but if he is unavailable, the responsibility can shift to another close male relative, a brother, an uncle, or even her own son once he reaches adulthood. This arrangement ensures that a woman's marital rights are always mediated through a male figure in her family, regardless of her age or circumstances. Independence, education, or financial standing do not erase this requirement. Saudi Arabia has seen some notable reforms in recent years. Women can now travel abroad, apply for passports, and access many services without seeking daily permission from a guardian. But this system of guardianship over marriage remains unchanged, standing out as one of the few areas where legal progress has not carried over. The contrast is stark. New freedoms coexist alongside a tradition that still gives family authority the final say on marriage. Not every country ties approval to family power, though. In other places, it's bureaucracy and technology that determine whether a wedding counts. India's mandatory digital marriage. In India, weddings have long been defined by rituals, ceremonies, and layers of tradition. But alongside the cultural spectacle, state authorities are steadily pushing couples into the digital realm. Several regions have begun requiring marriages to be logged through online systems, often linked to Aadhaar identification, turning what was once entirely ceremonial into a bureaucratic process managed on a server. Without that entry, a marriage might be recognized socially or religiously, but it lacks the full legal standing the state requires. Officials present the shift as an effort to curb child marriages, reduce fraud, and give women cleaner access to inheritance and property rights. By funneling registrations into centralized databases, marriages become traceable in ways that handwritten ledgers or scattered local records never allowed. The intent is modernization, but the system also ties personal milestones tightly to government technology. For those in cities, the change can feel like another irritating administrative step layered onto wedding planning. But in rural areas, where internet access is inconsistent and digital literacy remains low, the online requirement creates real obstacles. A missed upload doesn't just delay paperwork, it can leave a couple legally unrecognized, with no clear timeline for correction. The result is a system where even after the vows are exchanged, legal status still depends on successfully navigating data entry. And India is not alone in adding new gatekeepers to marriage. Other countries extend control even further, judging not only paperwork, but the character of those who wish to marry. China's social credit marriage block. In China, marriage isn't just handled through ceremonies and certificates. It can also be affected by the state's broad system of social and administrative monitoring. While the government's social credit framework is most visible in areas like travel restrictions, lending access, or business licensing, reports note that blacklists connected to unpaid debts and other violations sometimes spill over into other bureaucratic processes. In some municipalities, officials have used these records during application reviews, introducing an added layer of scrutiny that can complicate what should be a straightforward step toward marriage. What makes this striking is the way seemingly unrelated behaviors are pulled into the equation. Something like lapsing on a loan or ignoring a fine may have no obvious connection to a couple's relationship, but such issues can trigger flags in the local registry system. Officials can treat these red marks as signs of unreliability, folding everyday personal conduct into decisions about whether or when marriages proceed. The government's stated reasoning follows a consistent theme. People who fail to meet routine obligations are seen as poor candidates for long-term legal commitments. The logic reinforces a model where social order is directly tied to private life choices. Instead of families or communities shaping marriage decisions, digital records and compliance scores become the deciding reference point. This trend shows how administrative oversight can redefine who is considered ready to marry. And while this represents one type of state-imposed filter, other governments take an even harder line, creating legal barriers that erase entire categories of unions once they cross the border. Russia's foreign marriage firewall. In Russia, marriage law comes with a rigid boundary that blocks recognition of same-sex unions performed abroad. A constitutional amendment enacted in 2020 defined marriage strictly as a union between a man and a woman, and that definition now overrides everything else. For foreign couples or Russian citizens married elsewhere, the effect is immediate. The certificate that held legal force at home carries no weight once presented inside Russia. The fallout is extensive. For couples where one partner is Russian and the other a foreign national, marriage normally unlocks rights to residency, spousal visas, and access to family-based immigration. Under Russian law, these doors remain shut. The foreign partner is treated as unrelated, regardless of marital status abroad. The same applies to inheritance. A surviving spouse cannot rely on the automatic transfer of property, even if the two were legally married and jointly recognized under international law. Parental rights also vanish in this framework. A spouse listed as a legal parent overseas may be stripped of recognition if disputes arise in Russia's courts. The law does not just overlook foreign records, it deliberately nullifies them to reinforce a single legal definition. For couples crossing that border, the loss is clear. Protections tied to marriage can dissolve instantly. And while that's a stark example of erasure, in other countries the barrier isn't ideology but bureaucracy itself, where marriage becomes an endurance test of paperwork and patience. Germany's marriage obstacle course. In Germany, marriage starts not with a ceremony but with a careful inspection of documents at the local registry office, the Standesamt. Couples cannot even set a date until officials confirm eligibility. Standard requirements include certified birth certificates, proof of residence, and paperwork confirming neither person is already married. For foreigners, the process expands. They must obtain an Ehefertigkeitszeugnis asterisk, a certificate of no impediment to marry, which often requires documents validated with apostils from multiple offices abroad. That step alone can take months to resolve. Once the paperwork is accepted, some states add further conditions. Couples with large age differences or younger partners may be asked to attend advisory sessions where officials explain the legal framework of marriage. Though framed as guidance, it means additional waiting periods before final approval. The emphasis is on certainty. The state wants written proof and demonstrated understanding before granting permission to wed. The entire system is deliberate by design. It prioritizes accuracy over speed, ensuring that every marriage is fully documented and formally acknowledged. Yet this thoroughness has a cost. For many couples, planning a wedding feels tied less to personal choice and more to the pace of state paperwork. Not every country enforces detailed filings. Elsewhere, the biggest challenge to marriage comes from something far simpler: finding people to legally stand by and watch it happen. Australia's Outback wedding witnesses. In Australia, weddings cannot be finalized without two adult witnesses physically present at the ceremony. The law requires both witnesses to be over 18 and to sign the official marriage register on the spot. In cities, this is rarely an issue, since friends and family typically fill those roles. But in remote areas, particularly the Outback, the requirement can turn into a logistical challenge. Couples who set out for a private or isolated ceremony sometimes discover that the law still demands extra hands to make it valid. When faced with this problem, couples often find practical but less than planned solutions. A passing traveler, a local worker, or even staff from a nearby roadhouse has occasionally been asked to step in. The practice isn't about bending rules, but about meeting them under unusual circumstances. Regardless of location, the law applies uniformly. A marriage cannot be registered until two witnesses sign alongside the couple. Unlike some jurisdictions experimenting with online verification, Australia has kept the rules strictly physical. The government insists on in-person signatures as proof of authenticity, even when that means solitude has to give way to strangers. The effect is clear. No matter how remote or spontaneous the ceremony, paperwork cannot be completed without those signatures. That tension between law and lived reality shows how enforcement can clash with lifestyle. And in other countries, a similar gap appears when laws against entire practices don't disappear, yet governments hesitate to enforce them. Canada's polygamy paradox. Canada, the rules on polygamy appear strict at first glance. It is a criminal offense punishable by imprisonment. Yet for much of the country's history, enforcement hasn't matched the law on paper. Polygamist groups have openly operated in provinces like British Columbia, while government officials often hesitated to pursue charges. The fear was that any prosecution could spark constitutional battles over religious freedom, creating a stalemate where the law existed but was rarely tested. That changed course in 2011 when the Supreme Court of British Columbia ruled the ban constitutional. The judgment centered on documented harms, stressing that risks to women, children, and vulnerable communities outweighed arguments of religious protection. With that decision, prosecutors were given clear constitutional backing to proceed. But legal clarity didn't translate into consistent practice. Only a handful of prosecutions followed, many of them drawn out and controversial, with critics pointing to selective application and lengthy delays. As it stands, Canada's marriage law creates a paradox. Polygamy is decisively outlawed, yet its enforcement is uneven and unpredictable. On paper, the crime carries absolute penalties. In reality, it is policed inconsistently, shaped more by politics, resources, and hesitation than by the statute itself. It's a sharp reminder that what the law declares and what officials enforce are not always the same. In other places, however, the state doesn't hesitate. It goes so far as to demand medical proof before a wedding can even begin. Brazil's mandatory medical screening. In Brazil, the path to marriage sometimes includes a medical requirement before a license can be issued. Certain municipalities require couples to present proof of an HIV test along with their application. The rule is not national, so depending on location, couples may face different paperwork. The important detail is that a positive test never blocks the marriage itself. It only leads to mandatory counseling sessions. These conversations are meant to provide medical information, highlight treatment options, and encourage openness between partners. Officials justify the rule as a public health safeguard, tying marriage to awareness and prevention. By making the test part of the licensing process, the state ensures both partners formally acknowledge any results. Critics, however, argue that it goes too far by putting private health information into the hands of clerks and administrators. What should remain between two people becomes part of the official record, watched over by government offices. For couples facing the requirement, the experience can create pressure beyond the usual preparations of planning and ceremony. Instead of simply managing invitations or venues, they must also schedule medical visits, present paperwork, and accept counseling sessions if results demand it. Marriage here is contingent on a sealed test result, turning a personal milestone into another tier of state-managed disclosure. In Brazil, the wedding license hinges on health records. In another country, though, the license itself comes with something even more unexpected, a built-in expiration date. Mexico's temporary marriage contracts. In Iran, marriage law includes an option that differs radically from the lifelong contracts most people expect. Known as ***, or temporary marriage, it allows couples to set a fixed duration for their union, with terms ranging from a few hours to several years. The arrangement is legally valid under Shia Islamic law and carries many of the same rights as a permanent marriage, from financial obligations to recognized spousal status. But it expires automatically once the agreed term runs out. When that term ends, the marriage dissolves without the need for a court proceeding or formal divorce. If both partners want to continue, they can renew with another contract, setting new terms much like extending an agreement. Supporters argue this structure gives couples flexibility, especially in situations where long-term commitment feels uncertain. It offers a way to test compatibility, avoid costly legal battles, and frame relationships in terms of agreed expectations. Critics, however, argue that **** undermines the very principle of marriage as a lasting union. They warn it reduces relationships to transactional agreements, open to exploitation, particularly when power or financial resources are uneven. The debate reflects broader tensions between traditional family expectations and legal structures designed for temporary arrangement, while temporary marriages challenge ideas of permanence. In other places, the state intervenes not by limiting time, but by deciding who must undergo extra steps before approval. Singapore's Harmony Counseling. In Singapore, couples with different racial or cultural backgrounds sometimes find themselves directed towards special counseling programs before their marriage is fully registered. These initiatives are not applied to every pair automatically, but in selected cases, the government introduces sessions designed to help partners address the realities of life in a multi-ethnic society. The program is framed as support rather than punishment. Officials describe it as a way to prepare couples for challenges that may arise from differences in language, traditions, or family expectations. In a country where racial harmony is a central policy goal, the sessions carry a broader national purpose, strengthening stability at home to prevent divisions in society. By bringing partners together to discuss issues before they surface, the government attempts to manage risk through proactive guidance. Not everyone agrees with the approach. Critics highlight that the system singles out interracial couples based solely on their background, applying extra hurdles that same-race couples never face. This raises the question of whether the state is providing help or engaging in subtle social engineering by requiring additional steps tied to identity rather than individual need. For the couples involved, the distinction matters less than the practical reality. Their marriage application doesn't move forward until the sessions are complete. Singapore's case shows how governments sometimes intervene far before the wedding day, adding conditions based on who the partners are. In other places, the focus shifts to who they are relative to each other. South Korea's age gap scrutiny. In South Korea, large age gaps in international relationships can attract more than just attention from friends. They can trigger formal reviews by the state. When a Korean citizen applies to marry a foreign partner, especially from regions that officials classify as high risk, a noticeable age difference invites added screening. On paper, the rationale is to prevent fraud, forced marriages, or trafficking. In practice, legitimate couples often find themselves treated as though they must prove their relationship is real before it can move forward. That review can come with strict conditions. Authorities may request financial records to make sure the Korean spouse earns enough to provide support. Foreign applicants from flagged countries are often expected to demonstrate Korean language ability as well, under the assumption that communication struggles raise doubts about whether a marriage is genuine. Together, these checks frame a wide age gap paired with foreign nationality as a red flag by default. Interviews also play a role in the process. Immigration officers may ask how the couple met, how daily life is shared, and whether the family formally approves. Officials frame this as a safeguard, but many describe the tone as closer to a legal interrogation than a routine application. Did you know an age gap could trigger government questioning before a wedding? And South Korea isn't the only place where couples face layers of official hurdles just to legitimize their unions. Thailand's foreign marriage maze. In Thailand, foreigners who want to marry a Thai citizen often discover the process is laden with paperwork that can stretch far beyond the ceremony itself. The first major step is obtaining an affirmation of freedom to marry from your embassy, a document confirming you are legally single and able to wed once issued. It must then be submitted to Thai officials as part of the application. From there, marriage becomes as much about document handling as exchanging vows. Financial scrutiny is one of the biggest hurdles. Immigration authorities frequently require evidence that the foreign partner can support themselves, with higher income or savings thresholds applied in recent years. Bank statements, tax records, or formal letters are all subject to close examination, and inconsistencies can stall the process. Even couples who readily meet the requirements often face delays simply because of the volume of material required to satisfy officials. Every document must also appear in Thai. Certified translators prepare the files, and multiple ministries must legalize each record before it is accepted. Couples report that errors or missing stamps can force the entire file back to the beginning, stretching timelines from weeks into months. For those living outside Bangkok or in rural areas, the repeated trips add both cost and stress, turning an intended celebration into a long administrative test. Thailand's legal maze shows how a marriage can be judged by paperwork long before the ceremony. In another country, officials go one step further, placing not only documents but a person's mind under review. The Philippines psychological test. In the Philippines, marrying across national lines has, in some cases, come with an extra requirement, a psychological evaluation for the foreign partner. Authorities have used this step in marriage and immigration proceedings not as a casual suggestion, but as part of the formal review process. Without completing it, applications can be delayed or even suspended, leaving couples in limbo while waiting for clearance. The evaluation itself is usually conducted by a licensed and accredited professional. It follows established clinical criteria rather than informal questioning. The results generate a written report, which is then submitted alongside the rest of the couple's documentation. Officials frame the purpose as protective. The check is meant to reduce the risks posed by unstable or exploitative partners, with the state presenting it as a safeguard for Filipino citizens. But for the foreign spouse, this requirement pulls a deeply personal matter into public view. Mental health, normally protected within the private realm of medical confidentiality, becomes a deciding factor for marriage eligibility. Approval depends not only on meeting social and legal standards, but also on whether a professional's assessment clears the relationship for recognition. This approach shows how marriage law can shift from regulating paperwork to scrutinizing individuals themselves. For some couples, the obstacle is not psychological testing, but a mandate even more profound: the question of faith as a fixed condition of legality. Indonesia's conversion requirement. In Indonesia, marriage law makes religion a central condition for recognition. The state does not recognize purely civil marriages, so both partners must be listed under the same faith for the union to be legally registered. This framework turns interfaith relationships into difficult cases. Couples may otherwise meet all requirements, but unless they align under one religion, their vows won't carry legal weight. The specifics can vary, but in practice, Muslim-majority regions especially enforce conversion before approval. For Muslim women, rules are even more restrictive. Islamic law in Indonesia does not allow a Muslim woman to marry a non-Muslim man. In these cases, the expectation is that the man converts to Islam, with the conversion officially documented by authorities before the application proceeds. Without this step, the local registry office will not accept their paperwork, regardless of the couple's intention. Some couples try to bypass the rule by marrying abroad in countries that allow civil marriages, hoping to later have the certificate recognized back home. Yet recognition is uneven and often delayed, leaving their legal status uncertain. Others yield to the requirement, treating conversion as an unavoidable procedure rather than a purely spiritual step. Here, the state places limits on marriage through religious conformity. In another setting, those limits arise in a very different way, tying eligibility not to faith, but to obligations of national duty that must be fulfilled before any license is granted. Turkey's military service prerequisite. In Turkey, marriage law intersects directly with national service. For men, the registry office may require proof that military obligations have been completed or formally deferred before issuing a marriage license. Conscription is mandatory, and officials can delay or stall applications if records show a groom has unresolved service status. While authorities rarely frame it as a formal ban, couples often find their paperwork held in limbo until the matter is cleared. This link between marriage and military duty places service alongside other essentials like identification and residency as a precondition for entering into marriage. Registry clerks check for compliance as part of routine verification, which effectively uses marriage licensing to reinforce the conscription system. For many men planning to settle down, their military record becomes an unavoidable part of the conversation, something that must be resolved before the ceremony can legally proceed. The issue is even sharper for Turkish citizens living overseas. A man who has built his life abroad may return to marry and still face demands to account for his military service before his license is processed. In practice, this means couples abroad are often advised to settle service obligations first to avoid last-minute roadblocks when dealing with local offices. It shows how bureaucracy can redefine eligibility by embedding national duties into the marriage process. Elsewhere, the barrier is not military status, but a maze of legal and religious conditions that place faith at the very center of what counts as a valid union. Egypt's interfaith labyrinth. In Egypt, interfaith marriage is governed by rules that make the process highly restrictive and uneven. The strictest limitation applies to Muslim women. Under Egyptian law, they cannot marry a non-Muslim man unless he formally converts to Islam. Without proof of conversion, the marriage simply isn't registered by the state, leaving the couple without any legal recognition. Conversion is not just a private declaration of faith. In practice, authorities often require certification from Al-Azhar, the country's most influential religious institution, to validate that the conversion has taken place. This certificate serves as the official evidence needed to register the marriage. Without it, the partners lose access to rights that typically follow marriage, from inheritance claims to the legal standing of any children within the union. For Muslim men, the rules are more flexible. Marriage to Christian or Jewish women is permitted. However, even in these cases, family law continues to operate under Islamic principles. Property rights, custody decisions, and inheritance are all determined according to Islamic interpretations, regardless of the wife's faith. While some courts may apply these rules with different levels of stringency, the overall framework favors one side of interfaith unions and blocks the other completely. Egypt's system shows how marriage law can hinge almost entirely on religious identity. In nearby countries, the emphasis shifts to age, where even adulthood does not always guarantee the right to make marital choices independently. Morocco's under 25 approval rule. In Morocco, legal independence in marriage is shaped heavily by age. The official minimum age to marry is 18, but the Maudawana asterisk, or family code, places additional weight on family and judicial approval for younger women. In particular, those not yet 25 often find that guardian consent or a judge's ruling still determines whether their marriage can proceed. While the law frames adulthood at 18, in practice, the system builds in layers of oversight that keep family authority involved far longer. Legally, a woman under 25 can turn to a court if her father or guardian withholds consent. The judge is empowered to approve the marriage despite objections, but in reality, this path is rarely straightforward. Judges often view the absence of family approval as a serious warning, and many hesitate to override it. As a result, the theoretical option of judicial intervention becomes a barrier rather than a safeguard, reinforcing the expectation that family consent remains central. This weight of authority feels sharpest in rural communities, where social norms strongly align with tradition. There, family signature isn't just encouraged, but seen as essential, with paperwork unlikely to move at all without it. Only after passing the mid-20s age threshold do women consistently encounter fewer obstacles from guardians or courts. Morocco's model shows how one country can hinge marital rights on layers of age and approval. Elsewhere, the defining factor isn't age at all, but which religious system governs your future. Lebanon's religious court maze. In Lebanon, getting married means stepping into a system defined by religion rather than state law. There is no single civil marriage code that applies to everyone. Instead, family matters, including marriage, divorce, and inheritance, are handled by religious courts tied to one of the 18 officially recognized sects. Each sect maintains its own procedures, which means your rights and obligations depend on the religious jurisdiction you fall under. This structure creates sharp disparities. Sunni and Shia Muslims go through separate court systems, while Maronite Christians, Druze, and other communities follow their own rules. What counts as grounds for divorce, who gets custody of children, and how property is divided can all vary dramatically. For couples from different sects, the situation becomes even more complex. Unless one partner converts, the two may face conflicting systems that make it difficult to register or manage their marriage at all. Because of these obstacles, many mixed-sect couples look abroad. A civil ceremony performed in another country is the most common workaround. Once they return to Lebanon, they can apply to have the foreign marriage certificate recognized, but recognition often drags through layers of bureaucracy, leaving their legal status uncertain for months or years. This maze of religious and legal authority shows how marriage can be narrowed by structures far beyond the couple themselves. In a neighboring country, the weight of tradition and the law imposes a different kind of pressure, where questions of family honor can still shape whether a marriage is truly secure. Jordan's honor-based complications. In Jordan, marriage is not only a matter of law, but remains tied to the social weight of family honor. For decades, the country's penal code contained provisions that reduced sentences for so-called honor crimes. And although reforms have removed those legal allowances, their shadow still lingers. Families continue to treat marriage choices as reflections of public reputation, and disputes often spill into both courts and community circles. When a woman chooses to marry against her family's wishes, opposition can escalate well beyond disapproval. Relatives may argue that her decision damages the family's standing, and some have pursued legal challenges to restrict custody rights or dispute the legitimacy of the union itself. Even with modern reforms, judges sometimes consider these honor-based claims, leaving couples to defend a marriage license that is technically valid but vulnerable to external attack. This creates an uneasy mix of legality and pressure. Officially, the state has removed leniency for honor violence, but socially, families can still use the idea of dishonor to influence outcomes. The law may allow a marriage, yet the fight often continues afterward in family disputes and courts. Do you think legal recognition alone is enough if social forces still weigh so heavily? In Jordan, that tension persists, while across the border, the test isn't family honor, but whether conversion documents exist at all. Pakistan's conversion paper trail. In Pakistan, the legality of many interfaith marriages turns entirely on conversion paperwork. A non-Muslim who wishes to marry a Muslim must present an official certificate of conversion issued through a recognized Islamic authority. Without this document, the marriage application cannot proceed, and the state will not register the union, no matter how binding the ceremony feels to the couple themselves. That certificate is filed alongside the *nikahnaमा*, the official Islamic marriage contract, and treated as proof that the religious requirement has been met. The absence of the certificate creates an immediate roadblock. The registrar has no authority to recognize the marriage. This means what many view as a private matter of faith is handled as nothing less than documentary evidence in the eyes of the state. Conversion disputes often reach the courts. Allegations of forced conversion frequently emerge, especially when younger women are involved. Judges must then decide whether a conversion was freely chosen or coerced before ruling on the validity of the marriage. Until that judgment is made, the couple remains in a legal limbo, with their marriage neither fully recognized nor fully dismissed. In Pakistan, the validity of a marriage can hinge on a single stamped sheet of paper. And just across the border, another law shows how one of the most entrenched wedding practices can be treated at the same time as both universal custom and outright crime. Bangladesh's dowry law paradox. In Bangladesh, marriage law delivers one of its clearest contradictions. The Dowry Prohibition Act makes it illegal to demand, give, or accept dowry in any form, whether cash, property, or lavish gifts tied to a wedding. The statute sets out prison terms and fines as penalties, creating an official stance that seems uncompromising on paper. Yet dowry remains deeply entrenched in practice, woven into the fabric of most marriage negotiations. Refusing dowry demands can derail a match entirely, and for many families, the exchange is still treated as routine. Weddings may proceed with dowry at their core, despite the fact that the law defines the act itself as a crime. This constant clash between legal rule and cultural expectation leaves millions of unions existing in a gray zone where the very foundation of the marriage rests on something unlawful. Enforcement does little to deter the practice beforehand. Instead, the law most often comes into play after the wedding when disputes erupt. If a bride faces mistreatment or if disagreements over unpaid dowry escalate, families turn to the statute as a tool. Charges are filed in the aftermath, transforming the prohibition into leverage in marital conflict rather than a barrier against the custom itself. In Bangladesh, dowry exists simultaneously as tradition and crime, showing just how far law and culture can drift apart. And that same divide takes a very different shape in the next country, where the obstacle is not money, but the unequal weight of heritage itself. Sri Lanka's ethnic gatekeeping. In Sri Lanka, marriage law is divided across multiple customary codes rather than unified under one national framework. Alongside general law, groups such as the Kandyan Sinhalese, Tamils, and Muslims have their own state-recognized systems. These parallel codes mean that ethnicity and religion can determine not just how marriages are registered, but also who controls inheritance, how divorce is processed, and what property rights look like after the ceremony. Take the Kandyan Marriage and Divorce Act. It applies only to Kandyan Sinhalese, establishing property and divorce rules distinct from those under general law. For couples subject to this act, rights within the relationship may look very different compared to neighbors governed by another system. The state treats each code as binding, underscoring how personal status is filtered through ethnic identity in a way that persists throughout the marriage. Cross-ethnic couples face the most complicated decisions. They must formally choose the system that will govern their union, knowing that whichever they select defines future rights in areas like inheritance, custody, and divorce settlements. That choice can carry lifelong consequences, and once made, it legally binds both partners under that particular framework. If you had to choose a legal system before marrying, which one would you trust with your future? In Sri Lanka, that is more than a thought experiment. It is a practical reality. And nearby, another country shows how the very ability to marry can depend not on choice, but on whether the state recognizes you as a citizen at all. Myanmar's citizenship check. In Myanmar, marriage begins with a test of identity rather than ceremony. Both partners must present documents proving citizenship, usually a national registration card and supporting certificates, before a marriage license can be issued. Without this proof, the registry office will not process the application, leaving the couple without legal recognition no matter how committed they are. The rules hit minorities hardest. Entire groups denied citizenship under Myanmar's classifications are excluded, with the Rohingya being the clearest example. Because they are not recognized as citizens, their marriages cannot be legally registered at all. Couples may hold ceremonies within their communities, but without civil recognition, they lose protections in inheritance, custody, and property. The union exists socially, but never becomes valid in the eyes of the state. Even for recognized citizens, the process often turns into a struggle with bureaucracy. Delays, requests for unofficial payments, and obstruction by local officials make registration slow and uncertain. What should be family law is instead applied as a form of citizenship control, reinforcing who the government accepts and who it leaves outside the civic framework. For couples caught in these rules, the human cost is sharp. A relationship that feels whole in private life becomes invisible when denied on paper. And in another nearby system, the challenge is not citizenship itself, but official approval tied to questions of loyalty and national allegiance. Vietnam's party-approved weddings. In Vietnam, some marriages aren't just shaped by families, they're shaped by the state. For government employees in sensitive roles, such as members of the Communist Party, police officers, or civil servants, marrying a foreign partner often requires official permission. This step isn't a formality. It's a review process where the state can decide whether a private relationship is acceptable in light of political concern. Once the request is filed, the foreign partner's background may be checked, focusing on their personal history, financial situation, or family ties. Officials explain the scrutiny as a national security safeguard, designed to limit risks of foreign influence or unwanted external pressure on state institutions. The higher the employee's rank or access to information, the more detailed the vetting typically becomes, and decisions may rest on even small perceived risk. This requirement carries serious consequences. If approval is denied, the employee faces a harsh choice: pursue the marriage and give up their career, or preserve their position by abandoning the union. In this way, what most view as a personal milestone becomes a loyalty test, with the outcome determined not solely by the couple, but by the state's judgment of risk. Vietnam's rules remind us how marriage can become another tool for political control. And in the most extreme cases, marriage isn't even about background checks. It starts with the state deciding a person's very worth in society before they can even think about love. North Korea's class-based marriages. In North Korea, marriage isn't defined by romance or family preference, but by songbun asterisk, the state's rigid social classification system. Every citizen is assigned a status, core, wavering, or hostile, based primarily on family history and political loyalty. These labels are inherited, passed down through generations, and they shape nearly every major decision in life. When it comes to marriage, songbun decides who is considered an acceptable partner and who is not. Crossing the lines of classification is fraught with obstacles. A person from a higher status family risks losing privileges if they marry someone with lower standing, and local authorities can step in to block the match outright. Families often enforce these barriers as firmly as the state, fearing that a union with someone hostile could drag down the reputation and opportunities of the entire household. The system ensures that marriages reinforce the existing social order rather than blend across it. The impact extends beyond relationships. A favorable asterisk songbun gives access to better housing, employment, and education, while a marriage that lowers one's standing can quickly erase those advantages. In this way, unions become mechanisms for preserving class divisions and reinforcing political loyalty across generations. Here, marriage is not a personal milestone. It functions as a government tool for maintaining control. And in contrast, another country takes almost the opposite approach, turning marriage into a limited contract with an expiration date built in from the start. Iran's marriage subscription service. In Iran, marriage law includes a practice called asterisk sai asterisk, or temporary marriage, which creates unions that are formally recognized but designed to expire. Rooted in Shia Islamic tradition, sai allows a couple to set a fixed duration for the marriage, ranging from a few hours to decades. The terms are written into a contract that specifies both the time frame and the ma asterisk, a dowry that must be paid to the woman at the beginning. When that term ends, the marriage dissolves automatically, requiring no divorce procedures. Supporters frame this as a flexible, religiously endorsed solution for people who want companionship without the permanence of a full marriage. It provides a legal outlet for relationships within a strict religious framework, offering couples a way to formalize arrangements while avoiding the binding nature of a lifelong contract. Critics, however, point to the vulnerabilities built into the system. Because of its short-term nature, sai asterisk is often accused of leaving women exposed to exploitation, with little financial or social security once the union ends. Some describe it as functioning less like a religious safeguard and more like a legalized transaction. For that reason, it remains one of the most debated aspects of Iranian family law, balancing its religious legitimacy against modern concerns of fairness and protection. Here, marriage becomes a temporary subscription, ending not by court order but by the clock. Elsewhere, the issue is even more restrictive, with the very right to consent taken out of women's hands entirely. Afghanistan's guardian-controlled vows. In Afghanistan, the foundation of marriage law is structured around a guardian's authority rather than a woman's independent choice. Under the framework applied by the Taliban, it is the male guardian, or wali asterisk, who signs and validates the marriage contract. Without his approval, the union is considered legally void, regardless of the woman's wishes. This authority is not limited to guidance. A guardian has the legal power to confirm a marriage even if the woman disagrees, which makes her consent largely irrelevant in practice. The rule is especially strict in cases involving minors, where guardians may arrange marriages for girls long before they can meaningfully participate in the decision. The system erases the principle of consent, treating it as unnecessary once the guardian has spoken. By placing the contract entirely in the hands of the asterisk wali asterisk, the law reinforces a permanent state of dependency. Even adult women are treated as though they lack full legal capacity, with responsibility for one of life's most personal decisions shifted onto male relatives. In effect, marriage becomes a transaction overseen on their behalf, rather than an agreement built on personal choice. This structure shows how legal authority can sit outside the couple themselves. In other places, control takes on a different form, not through guardianship, but through dividing marriages by religious identity and channeling them into entirely separate legal systems. Iraq's sectarian marriage documents. In Iraq, marriage is governed by a fragmented system where sectarian identity shapes every step of the process. The country has a national civil status law, but in practice, most marriages are handled not by neutral state courts, but by religious ones. Which court you go to and what requirements you must meet depends entirely on whether you are Sunni or Shia. Even the basic wording of a contract can change depending on which authority is reviewing the documents, meaning couples are judged by different legal standards from the very beginning. The requirements diverge further once the paperwork reaches the courts. Sunni and Shia authorities apply distinct interpretations of family law, including how many witnesses are required and what language must appear in the marriage certificate. Couples from different sects often encounter the most obstacles, as they may be told to secure multiple approvals and clerical endorsements to have their union recognized. Conflicting interpretations leave them waiting in uncertainty, sometimes with no clear answer on which decision controls their marriage. The marriage certificate itself usually records sect affiliation, binding couples under one system for everything that follows: divorce, inheritance, and custody. That single designation locks their legal future to the framework of a chosen sect, with little room to change course later. Recent amendments have stirred even more debate, as lawmakers have explored lowering the legal marriage age below 18 in certain cases. Changes critics argue weaken protections for children. In Iraq, bureaucracy and belief are inseparable, and couples must navigate both. In other parts of the region, however, it is not sectarian courts, but local traditions that wield even more authority over marriage. Yemen's tribal law override. In Yemen, the authority that determines whether a marriage is valid often rests outside the civil code. On paper, the law sets minimum age limits and procedural requirements, but in many rural areas, those rules give way to tribal traditions enforced by local councils. When elders approve a union, it is regarded as legitimate within the community, even if it conflicts with national law. Social recognition provided by tribal structures usually carries more weight day to day than formal approval from the state. This arrangement gives tribal leaders enormous influence. Their decision can overrule age restrictions, bypass questions of consent, and sidestep formal registration in government offices. For families, the critical factor is not compliance with the civil code, but acceptance from the tribe, since that brings security, recognition, and protection within the community. The gap between state rules and tribal customs leaves couples in a dual system where one authority grants approval locally, while another may withhold it nationally. Courts are well aware of this divide and often avoid pressing the issue. Judges rarely challenge tribal rulings directly, since doing so risks conflict with local leaders and instability for the families involved. Instead, they leave marriages recognized by tribal law standing untested. In Yemen, the contrast is clear. The law written by the state rarely overpowers the law practiced in daily life. And in one nearby country, that same imbalance takes root in a different form, where entire clans, not just families, decide whether a marriage can exist at all. Somalia's clan-based approval. In Somalia, marriage often operates within the framework of *0*, a customary system that continues to guide daily life in many rural regions. Under this tradition, unions are judged as agreements between clans rather than private arrangements. Clan elders hold decisive influence, evaluating whether a marriage will strengthen alliances, prevent disputes, and maintain balance among kin groups. Their approval may not be the only step in the process, but it frequently determines whether a marriage is recognized in practice. For couples, that influence carries both weight and risk. When a union is arranged within accepted clan boundaries, it can secure peace and reinforce networks of trust. But if elders reject a match, especially one that crosses rival clan lines, the consequences can go far beyond family tension. Couples may be pressured to separate, and disputes can escalate into conflicts that involve entire community. In this sense, marriage negotiations resemble political agreements as much as personal commitments. Another defining feature is the Yarad asterisk, or bride price. This payment is delivered not to the bride, but to her family as a sign of obligation and interclan bonding. It symbolizes the union as a contract between groups rather than a private exchange between two individuals. Somalia's model reduces marriage to a community pact, with family identity outweighing individual preference. Compared to Western systems focused on personal choice, it highlights how fundamentally different the rules of marriage can look just a border away. Ethiopia's ethnic marriage borders. In Ethiopia, the rules of marriage shift depending on where you live and which ethnic group you belong to. The country is organized as a federation of ethnic-based regional states, and each region has the power to legislate its own family code. There is no single nationwide law that governs everyone. Instead, the system creates internal borders where rights and requirements change as soon as you move from one state to another. For couples, this fragmented structure can lead to confusion. A marriage recognized in one region might face different rules elsewhere, with variations in minimum age, property arrangements, and divorce procedures. Partners from different states often find themselves caught between overlapping codes and legal uncertainty, never quite sure which framework will prevail if disputes arise. What should be a single family law system instead becomes a patchwork of competing rules, leaving couples vulnerable to uneven treatment. Customary laws tied to specific ethnic groups add another layer. These traditions are officially recognized under federal law, meaning that local customs are enforceable alongside regional codes. As a result, two marriages that look similar on the surface may carry very different rights depending on ethnicity and geography. Ethiopia shows the impact of dividing marriage law by community and region. In another country, that fragmentation looks different, not by ethnicity within a federation, but through entirely separate marriage systems that couples must choose between from the start. Nigeria's triple law system. In Nigeria, marriage comes with a decision that carries permanent legal weight, choosing which of three official systems will govern the union. Couples can marry through the civil system under the Marriage Act, which enforces strict monogamy and is recognized by the federal state. They can also marry through customary law, reflecting ethnic traditions that permit polygyny. In much of the North, there is a third option: Islamic marriage under Sharia law, where multiple wives are allowed under conditions set by religious courts. The choice matters because each system controls different aspects of family life. Under civil law, only one partner is legally recognized at a time. Customary and Sharia systems both permit more than one wife, but with different obligations for inheritance, property, and divorce. The overlap creates major complications. A person married under civil law may still attempt to contract a customary marriage, leaving courts to sort out conflicting claims of legitimacy. These contradictions often come to the surface during disputes. Cases of succession, division of assets, or custody battles can hinge on which system the original marriage was registered under, and sometimes competing courts issue conflicting judgments. The state recognizes all three systems, but enforcement is fractured, leaving families caught between multiple interpretations of the law. When the framework matters as much as the partner, couples face a heavier burden, choosing not just who to marry, but which authority to bind themselves to. How would you feel if one wedding defined your rights for a lifetime based on paperwork alone? Ghana's bride price regulations. In Ghana, marriage under customary law is closely tied to a payment known as the bride price. This is not just a cultural expectation, but a step often necessary for both social and legal recognition of the union. The groom's family is expected to present gifts or money to the bride's family, with the form and amount varying based on tradition and circumstance. What matters most is not the exact value, but the act of giving itself, which signals respect for the bride's family and validates the marriage in customary terms. The practice has sparked ongoing debate. Supporters frame it as a symbolic gesture, acknowledging the joining of two families. Critics argue it adds a transactional dimension to marriage, suggesting that women are being valued through financial exchanges. These different perspectives highlight why the bride price continues to divide opinion in modern Ghana, even as it remains deeply embedded in customary practice and legal recognition. The consequences of ignoring this requirement can be serious. A marriage without evidence of a bride price may face challenges in court, and in some cases, judges have ruled such unions invalid. That means years of cohabitation or raising children together may carry no weight if the initial exchange was skipped. For couples, the stakes are personal and legal at once. And in another country, those same stakes took on an entirely new form when legislators tried to merge clashing marriage systems into one. Kenya's marriage law showdown. Kenya's overhaul of its marriage laws in 2014 was supposed to streamline a fragmented system, but instead it sparked one of the country's most contentious legal debates. The Marriage Act was introduced to unify 5 recognized forms of marriage: civil, Christian, Hindu, Islamic, and customary, under a single law. The intention was clarity. The reality was contradiction. The sharpest clash came where these systems overlapped. Civil marriages were declared strictly monogamous, while many customary unions permitted polygyny. The law specified that someone already married under customary law could not then marry under civil law. Yet in practice, overlaps persisted, with men attempting both, forcing courts to determine which unions were valid and who counted as a lawful spouse. This uncertainty spilled directly into disputes over inheritance and legitimacy, where widows and children were left to argue their status before judges. The act also stirred controversy by removing a long-standing requirement that existing wives' consent before a new wife could be added to a polygynous union. That change triggered outrage among women's groups, who saw it as stripping away one of the few protections available to women under the law. Kenya's attempt at reform shows how a law aimed at simplifying marriage can end up multiplying disputes. Instead of resolving contradictions, it created new ones, proof that when governments try to tidy up love, they often leave couples with even bigger headaches. From France allowing posthumous marriages to Utah permitting cousin weddings only after 65, and Kentucky banning a 4th marriage to the same partner, it's clear marriage law is anything but consistent. These rules reveal how governments reshape personal commitments into legal puzzles that range from the curious to the restrictive. Some of these statutes serve symbolic purposes, others still carry real consequences for couples navigating the system today. But together, they show how love is never entirely separate from law. Which of these struck you as the strangest? Leave your thoughts in the comments below and subscribe for more legal oddities.